Amazaga. Mr. Hanses, is that pronounced correctly?
Hanses.
Hanses?
Yeah.
We'll be glad to hear from you.
May it please the court. Companies cannot succeed if there's no protection for their investment in their confidential information and documents. To protect confidential information, including trade secrets, Airfax required the employees to sign an employment agreement that contained a clause that said you couldn't share confidential information with third parties, and that upon termination of employment, you had to return all confidential information. Mr. Amagaza signed that employment agreement, but contrary to those terms, he did not return confidential documents, including trade secrets. After termination, he obtained trade secrets through the use of passwords and a username to access trade secrets in an online storage device, and he shared trade secrets and other information with third parties in the same industry. Airfax had no choice but to hire lawyers and forensic experts to file suit and track down and recover the confidential information and verify to the extent to which he had shared it with third parties. Included in what he took and disclosed to a third party was a fair by rule flowchart, which this court ruled in the last appeal was a trade secret. The flowchart contained processing logic of Airfax ticket card process, which is the critical asset of their company. As this court found in the first appeal, the flowcharts had economic value because the expert arrangement of the data was unique and was information not available to others. Pursuant to count one of the complaint for breach of contract, Airfax sought to recover attorney's fees and expenses of tracking down the trade secrets and the breadth and determining the breadth of the confidential information he had failed to return. The district court, however, disregarded the rulings of this court and found that it was immaterial that Mr. Amagaza had accessed the flowcharts in direct disregard of his contract provision and turned the flowcharts over to a third party.
Did Mr. Hines, did the district court ever consider section 3.2 of the agreement in deciding whether the appellee possessed implicit authority to keep the documents?
Your Honor, the court only exercised that, made that determination with regard to one of the documents, not the flowchart, Your Honor, but only one document, and that was, Your Honor, the proration framework documents. The court held that for purposes of that specific trade secret, which is different, of course, than the flowcharts. The flowcharts he got by using a password, and he went into this online facility using a password and a username 1 month after his employment had been terminated. And the court said—
I want to get some clear on where you're going. The flowchart argument you have is that they were trade secrets and that you should have received damages for the use of the trade secret. Is that your argument?
Well, there's two. We're entitled to damages pursuant to the breach of contract for his failure to return all the documents. And we're entitled, those damages, the contract damages are those that are envisioned by the indemnification clause, that if we spend money tracking down these documents that you didn't return in conformance with this provision and tracking them down from third parties.
Well, some of the, I can never keep all these straight, but some of the documents, the district court made a factual finding, or it might have been a finding of combined law, in fact, that Mr. Amazaga had permission to retain the documents so that he could be consulted after his employment terminated, and that therefore he could not have violated, he could not have breached the contract in that regard. So are you challenging that finding?
I'm challenging that one as well. So that's the pro rata documents. So we just addressed the fair.
So the pro rata, is that what was involved with the Alaska Airlines?
Yes. 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 And that's the document he was one of the documents he was working on when he left.
So what's your claim on the pro rata documents?
On the pro rata documents, this court found that they weren't misappropriated in the last, affirmed the trial court's ruling in the last appeal that they weren't misappropriated under the Trade Secret Act. I don't think that ruling is binding with respect to breach of contract. A contract says you return the documents. Under the Trade Secret Act, you have to find misappropriation.
The district court determined that he had the implicit consent to retain the pro rata documents.
The court did find that. However, I think that implicit consent concept is contrary. In order to waive a contract right, you need an intentional and relinquishment of a known right. That implicit authority isn't sufficient to satisfy that standard that applies in a contract case.
I think opposing counsel says that I think this is right, under Maryland law, there can be an oral modification of that type of contract, including by conduct, that would alter that term of the written contract.
The case law that I cited and read, and my understanding of contract law and what I understand is that you have to have an intentional relinquishment of a known right that he should have returned.
Well, does it require it to be in writing? That's I mean, if the district court made a factual finding that he was entitled to this and, you know, to keep these things, what's our authority to overturn that finding?
There is an integration clause 10.3 that requires that any changes have to be in writing. Yes, 10.3. The agreement will not be modified except by an agreement in writing executed by the parties thereto. Furthermore, the provision that restricts, prohibits people from employees from sharing the information or confidential information required the written explicit notice from the president of the company to be able to share it. So there's two clauses that would require a written finding.
Did the district court even make an explicit royalty determination under that Maryland statute?
The district court, that's moving to the damages we seek for the royalty under the misappropriation. The court made a finding that there was no right to royalty damages because of the commercial use requirement. And as the court in Stagecraft, Justice Gorsuch now ruled that there is no requirement for commercial use in order to collect royalty damages in the case of a trade secret, because the statute itself says mere disclosure is sufficient.
So in other words, you could recover for unauthorized disclosure without commercial use.
Yes, and that's what the court held. That's what I think this court should hold, and that's what Stagecraft holds, and I think that's consistent with the law.
Well, let's assume that Stagecraft's theory applies. What are your damages?
Our damages were determined pursuant to the expert testimony of Ms. Riley, and she said that the damages could be between $3 million for a 3-year license. It's $440,000 for a 3-year license, or $293,000 for a 2-year license. And she calculated that the overall license fee was $3 million. She apportioned it only to 25%. However, I mean, I would, if the court.
Can I ask you, so where does the license fee, where does that number come from?
The license fee comes from, they sell what they call their ticket guard software, which is their central asset that they use to audit tickets. And a portion of that software has what's on these flow charts. The processing logic for a portion of that software that it's used in connection with that software is set forth in that trade secret. That's the flow charts. And it's only the back end of the system that use that processing logic on the flow sheets, and only a portion of that back end portion. And so she attributed only 25% to that. And she did that because only 27% of the tickets were used that part of
But that assumes that would be the traditional commercial use of the license. And here your argument is that it doesn't matter whether it's commercial or not because the statute doesn't require it. But then you're using a commercial definition of damages to get to the royalties in this case.
I think what I would rely on is the universal computing logic, which says when someone improperly.
That requires commercial use, doesn't it?
I don't think it requires, in order to calculate the damages based on the licensing. I think that the point of the damages are that essentially Fairportal, the company that they wanted to. So your devalue value, if it's disclosed to the commercial market, the value of the license is less. And I think it is a good proxy in any circumstance because while it's a secret, we get a licensing fee of a certain amount of money. If it's not a secret, that licensing fee is diminished. And I think it's a fair proxy. That is the impact of disclosing it, whether it's a commercial use or not. And I don't think it's a improper measure.
Can I take you back for a moment just to the issue of damages for the the use of the various materials in this case, and in particular, I want to focus on paragraph 6.1 of the employment agreement that talks about the damages, that the requirement to indemnify your client for, as the clause says, resulting from or directly or indirectly arising out of any material breach of any material provision. So it's not just that the provision has to be material, but that the breach itself has to be material. So what is the material breach in this case?
Well, the provision she found, the judge found that it was material. I sense from your question that you're aware of that. She found that the provision was material.
Yes, no, there's no dispute about that.
Right.
I'm getting at is what's the material breach?
The material breach is the breadth to which he used the documents, and he took multiple documents. The court recognized that it was a material breach when it entered an injunction.
Well, but the damages that you're primarily seeking are the expenses of investigating the breach, but that investigation didn't reveal any damage. So what's the breach?
Well, it did reveal damage. It did. Well, I mean, that's a post hoc analysis. The obligation on my client with respect to a trade secret is to keep the trade secrets confidential or they lose their value. Part of that obligation to use reasonable steps to ensure that the trade secrets are protected is if they're disclosed to a third party, and you know that, you have to go get them. And so that is a natural consequence of damages that were. It's a material breach in that sense because we have to go out and expend the money to collect them. Whether or not at the end of the day, the court after we've gone out and collected all these documents and rooted through them and found out whether one by one some may or may not have been trade secrets or there may or may not have been damages because a third party didn't actually use them or a third party or he didn't actually use them. That's after the fact analysis that you don't consider in connection with awarding attorney's fees because the obligation is to go get them.
Well, and in fact, under Maryland law, in materiality, a question of fact, and therefore our review of your claim about that would be clearly erroneous, wouldn't it?
Well, I think that the court did not apply the proper standard in determining whether there was a material breach because I've cited a Glenn versus Impact case, which is a case involving recovery attorney's fees for breach of a confidentiality provision and failure to return the exact same provisions as this case. And the Maryland court looked specifically to whether the parties contemplated that this would be a damage in the event of a disclosure. And I think that's the reason
even though that language is in the contract, and this may repeat a question I asked earlier, the district court made a finding that the defendant was authorized to retain some of these documents so that he could be consulted after his appointment terminated. So in view of that finding, if he was authorized to retain the documents, how is there a breach of contract for the investigative expenses and that sort of thing if he was authorized to retain the documents?
Because it was contemplated that if he didn't return them, I think the answer is that is only with respect to one document that the court
And
made that
which one is that?
the proration.
And isn't that what you want the investigative expenses for, is the proration documents, the Alaska Airlines stuff?
No, I want it because we had to look for any documents. But the fair by rule flow chart, the court found without question that he shouldn't have taken it from the online service. And so there's no doubt about it that he went to the online service. He took them out of the online service. He took them out of the online service using the password that he was given. And when he took them out, after he was no longer working, he breached the clause. So, and the court specifically found that not only had he breached the contract there, but also he had misappropriated the document under the Maryland Trade Secret Law. So with respect to that document, there's no question that he breached it. But I still thought, so there's no question about that document. And then the other documents, she said, yeah, he breached it. There were 4 or 5 other documents. She said he breached it, but I think that document's worthless. So you shouldn't have spent the time and money to collect it. But that after the fact analysis ignores the obligation of our client to go out and figure out essentially, if the court's ruling is correct, the court has to try, the employer has to try to make a determination. Oh, gee, we don't know what he has, but we have to spend the money to go out and find out what he has. And then once we find out what he has, we can't make a request for attorney's fees.
I think you've answered the question. So your time has expired. You do have some rebuttal time.
Okay, thank you.
Mr. Goldstein.
Thank you, Your Honors. Good afternoon, and may it please the court. This case was remanded to the district court to address only 2 issues. Whether you wanted a ruling on the merits on whether Amazaga breached paragraphs 2.2 or 4.2 of his employment agreement with Airfax by improperly retaining any Airfax documents, and if so, whether Airfax is entitled to any damages as a result. And second, a ruling on whether Amazaga violated the Maryland Trade Secret Act by misappropriating 2 flow charts that he sent to Fairportal, and if so, whether Airfax is entitled to any damages as a result of that. In all other respects, this court affirmed the district court's first decision, or Airfax didn't even appeal the rulings. Airfax seems to think that just because this court remanded the case to the district court to rule on those 2 issues, that all the district court's findings relating to underlying facts and credibility of witnesses are invalid, and it can feel free to renew its arguments about all the facts involved from trial, and that's just not the case. The district court correctly ruled that the 2 old documents that were on Amazaga's electronic devices, which was his computer and his phone, specifically an old commission table from 2013 and a straight sales processing diagram from 2009, were entirely without consequence to Airfax. Lee Ying, Airfax programmer, testified that straight sales processing diagram, for example, was outdated, wasn't even useful anymore. In addition, the findings in the district court's first memorandum opinion about those old outdated documents are still valid and binding. The court found that Amazaga was authorized to use Airfax documents to work from home just like everybody else. And the documents had never been accessed since they were put on his devices years earlier. That Amazaga's testimony regarding forgetting that the old documents were on his devices was credible. And Airfax didn't appeal those findings. those findings were made in the context of a MUSA claim, but they apply equally to Airfax breach of contract claim, and especially to whether there was a material breach. And moreover, Airfax counsel in the closing argument trial stated that the old documents were only relevant to Amazaga's credibility and that they were not making a claim for them. But now they're here trying to do exactly that. The prior rulings of the district court and the court and this court on the proration spreadsheets, that's the thing that Amazaga mailed to himself to answer questions, are also binding on the breach of contract claim.
Can I ask you about the proration document? So paragraph 4.2 of the employment agreement pretty explicitly says that the employee has an obligation to return all documents, and it doesn't seem to provide any kind of exception, at least on the face of the contract. The district court ruled, though, that your client had at least implicit authority to retain the documents because he was told he might be called upon to render additional service or advice. I don't see how the notion that someone might call him to ask him some questions somehow would lead a reasonable person to believe that he could retain documents that the agreement, let me finish, that the agreement expressly says that he can't keep.
Well, it wasn't just the district court that made that ruling. This court expressly upheld that finding, stating that it affirmed because Amazaga had the proration document with authorization. And that should apply to both the trade secret claim and a breach of contract claim. If he had it with authorization, and that's the ruling in this case already by the district court and this court, then he had it for both purposes. And there can't be a claim under MUTSA for retaining it and no claim, and in other words, there has to be consistent, a claim under both. It either is or it isn't, and it already has been found that he had authority.
Your opposing counsel says that there are different standards between the Trade Secrets Act and the breach of contract.
Well, I don't see it that way based on the rulings that have been made in this case, that if he was authorized based on the testimony and credibility of witnesses to answer questions about that document, and those requests were made by April Pearson, the owner of the company, and several other people, Lee Ying and Randy Laser. And those people, by the way, all did ask questions, not necessarily about that particular document, but they had a whole bunch of questions to ask them. So it was reasonable for him to have it and to respond to questions.
Did Mr.
Amazaga?
Amazaga assign his rights to those documents under Section 3.2?
What do you mean assign his? I'm sorry.
Back to Airfax. Any right he had to those documents?
Well, there probably would have come a time when he no longer needed it because time had made them useless, as it was in fact the case. But during the time that in the immediate months after he left, when there was the likelihood of questions about what he did and why, that's why he had the document with him and needed it to answer the questions. And these were based on, as I said, credibility of witnesses. And with respect to the flow charts, the evidence at trial showed, number one, that Fairportal, that was a company he sent them to, was not a customer or competitor of Airfax. That finding by the district court in the first opinion was not appealed. And Airfax contention now that Fairportal might someday become a competitor of Airfax is unsupported by any evidence. And it's contrary to Maryland's rejection of the inevitable disclosure doctrine in the Lejeune case. The evidence also showed that Amazaga did not have the flow charts when he left Airfax. We know that. Rather, a month later, when he needed something to show Fairportal what kind of work he did, he accessed this Lucid Chart website to save himself some time on downloading the flow charts that he had prepared previously. The evidence also showed that he prepared the flowcharts simply to help Airfax programmers understand how to deal with tickets that were missing passenger type information, such as whether it's a child or an adult or military or civilian, and how to deal with that. And that was for purposes of automating the fare by rule ticket processing. In fact, contrary to what April Pearson testified about those pages of flowcharts representing the entire processing logic of fare by rule ticket processing, Li Ying, the director of product development and senior programmer, said it dealt with only a small part of fare by rule logic. And the evidence showed that Amazaga prepared the flowchart using his knowledge of the ATPCO rules to try to help Airfax automate the audit process. And both Li Ying and Cindy Regan testified that as of the time of trial, more than 2 years after the creation of the flowcharts, Airfax still had not been able to automate fare by rule tickets. So that means Airfax either didn't understand the flowcharts and or the flowcharts were inaccurate and or the flowcharts simply were not useful to help with the automation process.
Mr. Goldstein, can I ask a question about 6.1 of the agreement that has the language requiring a material breach of a material provision of the agreement? I asked your colleague on the other side, what was the material breach and damage here? And his response essentially was, well, because we're dealing with an employee who was alleged to have taken documents, part and parcel of the damage is the time and expense necessary to make sure that, nothing untoward happened with respect to those documents, and that's an appropriate part of our claim for indemnification. But what's your response to that?
Well, first of all, 6.1 does require a material breach. Secondly, what actually occurred was that within the first month after Mr. Amazaga left Airfax, we sent them an email to their attorney and the forensic guy to explain what they could expect to find on his devices. And the password, gave them the devices to go pull whatever they wanted off. And they, in fact, deleted all the documents that we're talking about, the flow charts, the proration documents, and hundreds of other emails and correspondence that had Airfax in the email address that had nothing whatsoever to do with any of these documents. And so there was no lengthy process in terms of getting documents back like they make it sound. I mean, it's just not true. And their own...
I understood opposing counsel maybe in his brief to make the argument that since this was a contractual relationship with Alaska Airlines, that Alaska Airlines, upon being apprised that certain documents had gone out of the company's control and were held by Mr. Amazaga, required them to make certain changes to maintain the confidentiality of the documents. Is that accurate?
No, it's not accurate. The Li Ying and Pinar Taskin, the managing director, said that they didn't have to make any changes to the documents, any documents, as a result of anything Amazaga did. That's the testimony. There's no damages. There's no lost profits. They didn't even put on evidence of lost profits. They didn't put on any evidence of forensic damages, which is a requirement of proof of your case. It's not something you get as an expense afterwards. And we cited the cases, one of which they cited, that show that damages for forensic expenses have to be proven as part of your case at trial if you're claiming them. And I specifically asked Ms. Pearson at trial about what damages, if any, they had suffered from any of these documents, and specifically the flow charts. And she admitted that there were none, that She had no knowledge that any of the documents taken by Amazaga, including the flow charts, was ever used by him at American Airlines or anywhere else, or that they'd been used by anybody else at all, or that Amazaga ever received compensation for them. And that is the case. And Airfax counsel.
Well, what about the expenses of when you all sent Airfax counsel and forensic technicians this information and they did their work, would that be a recoverable expense?
If they had proved it as damages at trial, it might have been, but they didn't. I mean, I don't know what they claim that cost. I will say this, that in the last week, I learned that that Airfax sued its prior attorneys, the ones who Wiley Ryan that handled it up to the time of trial in DC Superior Court, alleging malpractice and breach of fiduciary duty, and represented in that complaint that their only two goals in bringing a suit against Amazaga were, number one, to basically get him to lose his job at Airfax as a result of his employment contract lose his job at American based on his contract with Airfax, which they lost and this court upheld, and to get back the documents. They got back the documents at the time of within a month of filing suit, and as I said, they lost the other claim, and yet they're complaining that Wiley Ryan ran up fees of nearly $1 million, which is hard to believe, raising all kinds of other issues and unsupported staff needs and claims. And when the basic goals that they say they were after in this case were met early on, and the decision, by the way, on the Airfax working at that Amazaga working at American was over 4 years ago. It's become apparent that they have other motives in going after this case. They also, by the way, said in that suit against Wiley Ryan that they knew that any monetary claim against Amazaga was substantially or entirely uncollectible. He's an individual, young guy. So you wonder what's going on here. And it's clear that I think that it's just a punitive action against Amazaga for leaving Airfax. Airfax tried to minimize the testimony of Lee Ying and Ms. Taskin, arguing they didn't know specifically what documents Amazaga took. But Ying was a director of product development and a senior programmer. If Pearson had directed her to make programming changes because of Amazaga, she clearly would have, Lee Ying clearly would have been aware of that fact. Similarly, Taskin was the managing director of Airfax and would have known if Amazaga did anything to harm Airfax after he left. She didn't say, I don't know, to the questions about damages. She said she was not aware of any harm caused to Airfax as a result of anything Amazaga took. And I also would note that in addition to not making a claim for lost profits here, they conceded in closing argument at trial they couldn't prove a conversion claim because they couldn't show that Amazaga deprived Airfax of any of the documents or the information in them. And Airfax also made a number of, as I said, inaccurate statements about the forensic stuff. Its own witness confirmed actually what we said, that the Amazaga gave full cooperation at the beginning of the case. We sent them an email in June 2015, soon after the case was filed, telling them what documents to look for, gave them his devices, and they acknowledged that they copied and deleted all the documents they wanted off of his devices, even gave us copies, because at that point we wouldn't have any copies. And they prepared a spreadsheet of the documents at issue in the case, in the search, including the flow charts, the proration document, the old documents, and so forth. And the spreadsheets, which were made at that time, showed that Amazaga never accessed the old documents in the years since he worked with them. He never accessed the proration spreadsheet. He never sent the documents to anyone else. That Airfax had everything back that it needed. And that anything, the misrepresentation was made about 16 months of forensic work. It's just not the case.
Mr. Goldstein, let me ask you about the trade secrets claim. You said earlier that the court, either our court or the district court, had ruled that your client's retention of the documents that were the subject of the trade secrets claim was authorized. Is that what you said? That it was authorized, the retention?
So that was with respect to the proration document, that his possession of that was post leaving Airfax was authorized. Yes.
So what's your argument with respect to the royalty damages under the Trade Secrets Act? I mean, the act on its face, difficult to ascertain damages.
Well, first of all, they relied on Michelle Riley as an expert to support that.
Let me finish my
I'm
question.
Sorry.
So the question is, why would we graft into the statute a requirement of commercial use where that language doesn't appear expressly or otherwise?
Because the case law has made it clear that that's what's required, that you have to show some kind of commercial use.
But aren't those cases interpreting the common law? And if you've got a statute that on its face doesn't say anything about commercial use, then why should we engraft cases that deal with common law trade secrets?
Well, you need to have some use. I mean, otherwise it's not a material breach in the first place. And
there are other cases. I mean, Judge Gorsuch seemed to write an opinion in Stagecraft or Stagecoach, something like that, that indicated that the breach was almost an entitlement to some form of damages per se.
Well, you're talking about the Stagecraft technology case, and we addressed it in our brief at pages 50 and 51. But Airfax, in arguing that case, ignores the portions of the decision demonstrating why a reasonable royalty was appropriate in that case, but not appropriate in this case. The 10th Circuit said that the defendant's use of the trade secret in general matters a great deal in the reasonable royalty analysis. And the court contrasted the situation where a trade secret was disclosed to somebody who didn't or couldn't make use of the secret and therefore couldn't do any serious damage, with intentionally disclosing it to an able competitor aware that it could be used to compete with the plaintiff. And in Stagecraft, the defendant had given the secret to a competitor of the plaintiff, which could and did use it to compete with the plaintiff. Fairportal was not a competitor, and it didn't use the documents to compete with Airfax in any way. It didn't even understand what the documents were for. And so it's not the same situation. And the cases dealing with use of misappropriated information show that somebody has to at least have tried to make use of it. It doesn't have to succeed. You know, if you tried to make use of the trade secret information and got nowhere with it, didn't make any money, yeah, there still can be a valid claim there. But where somebody didn't even try, there's no a claim for reasonable royalty. And in any event, as the district court pointed out, Riley's calculations were flawed in many ways. I mean, she based it on the value of the automation of the ticket guard auditing function and the two flowcharts role in automating the auditing of fair by rule tickets. But the evidence demonstrated that at the time of trial, 2 years later, Airfax was still unable to automate the fair by rule ticket processing. And in addition, the two flowcharts.
Goldstein, you're over a little bit. We gave opposing counsel.
Oh, I'm sorry.
So if there's anything else you want to add quickly, go ahead and do it.
No, it's all in the brief.
All right.
Leave it at
Thank
that.
you very much. Mr. Hanses, you have some rebuttal time.
I would just like to go right to stagecraft. And stagecraft says that all you need in order to be entitled to a royalty is disclosure. And then it says, while a defendant in Utah, and of course the Utah court statute was the same as Maryland's, can't avoid reasonable royalty because he discloses trade secrets. So you can't avoid it to others without making any commercial use of it. The amount of the royalty damages he must pay undoubtedly depends on the extent to which the trade secret was used. So it affects the damages, not the liability.
Entitled to anything more than a nominal damage here.
Because he wasn't innocent in what he did. He went to Fair Portal. Fair Portal was a company that Airfax had audited before on behalf of American Airlines, and Fair Portal had to pay $10 million to American Airlines because of this audit by Airfax of Fair Portal. Fair Portal had sold tickets and not properly paid. So what happened? What happens is he gets an interview, I guess, with Fair Portal, or wants to get an interview with Fair Portal. That's when he went a month after he was terminated and went in to the online database, used the trade secret, used the password, and took the fair by rule flow sheet, which is directly the document that would used to use it to assist to obtain that $10 million audit from Fair Portal. So he went in there to get that document to make use of it in his interview with the hope of getting a job. And he knew that he was exposing the company trade secret, something that was their trade secret, to a company that was a potential competitor or user of Airfax's logic. So I don't think it's not a situation. The issue isn't whether he used it. The issue is whether he disclosed it in the commercial setting where the value of that trade secret could have been reduced. The other thing that I wanted to point out, Your Honor, was I wanted to make clear here, back to the contract damages. The court goes through in the court's opinion and goes through each type of document. In the SPA pro rata framework, the court finds the implicit and says it was implicitly turned over, and he had implicit authorization. But with regard to the Fair Court says because he acted.
So let me ask a different question on the forensics discovery damages. Can you tell us where and what in the record shows those damages?
Your Honor, the trial counsel asked the court to be able to present attorney's fees and expenses. And the trial court said, not now, we're not going to do that now. We got to figure out whether you're going to win or not. And then we have to have the Fourth Circuit review the case. And if then we can come back. I don't think the record specifically says, so can I put on testimony of attorney's fees as well as forensic expenses? But I think he did use the word expenses and costs. So that's what the state of the record is. An idea that is improper because it's both the provision requires explicit authority and written from the president, and we never intentionally waive that right. Thank you.
All right, thank you very much.
Thank you.
Our court practice COVID, at least at this point. So we'll simply say we appreciate the arguments of both counsel. And if you'll, while you do that.
Thank you.
Do you need to go back? or Mr. Tyndall, my apologies.
Yes, sir, Your Honor.
We'll be glad to hear from you.
May it please the court, counsel for the government. My name's Amos Tyndall, and I represent the appellate, Justice McDonald. Problem in this case is that the sentencing court miscalculated the guidelines when it combined the conduct of several distinct, unrelated events for sentencing. That analysis resulted in finding acts as relevant conduct that were not part of the same course of conduct or common scheme or plan to the offenses of conviction. After that happens, the sentencing court applies upward adjustments from one event to the other, unrelated to the events of conviction. Finally, two adjustments are founded on factual findings based on insufficient evidence. These findings resulted in a sentencing range 8 levels higher than the appropriate range for this case.
Mr. Tyndall, it seems that the two of you disagree over the standard of review. What's your view about what standard of review we should use?
Your Honor, give me just a second here. Your Honor, the district court's application of specific offense characteristics is a mixed question of law and fact, and we believe that the court should review it de novo. Now, the sentencing court's analysis focused substantially on the elements of the offense of illegal possession of a firearm by a convicted felon, while overlooking the lack of any common purposes for the possession of the firearms. Multiple non-contemporaneous illegal firearm possessions must be connected by strong evidence of similarity to be considered part of the same course of conduct.
The counsel below objected to the relevant conduct classification in the district court.
Did he?
Yes. Did he?
Yes, Your Honor.
Okay.
And that requires something more than the fact that the offenses involved the illegal possession of firearms. Now, offenses are part of the same course of conduct if sufficiently connected or related to each other to warrant the conclusion that they are part of a single episode, spree, or ongoing series of offenses.
Aren't felon in possession cases inherently similar, or do we need to look at the circumstances of the offense, such as where it took place, so forth?
Well, Your Honor, based on the Duggars case, I would say certainly the court must look beyond the elements of the offense. If the elements of the offense were all that matter, then that's what the guidelines would have said. But that's not what the guidelines said.
Well, in terms of, I assume you're talking about the regular conduct. I mean, you can have drug offenses that happen 2 or 3 times a week, and you might go to Europe 2 or 3 times a year. I mean, both those seem to be regular conduct to me.
I'm sorry, you mean with the drug offenses?
Yes.
Would be if you do it 3 times, that's regular conduct. But certainly the circumstances under which a person commits a drug offense, according to this circuit's precedent, matters. And our contention is that the objectives of the offense and the objectives of the reason for possessing the gun matter in a firearm by a felon case. That if the elements of the offense were the only thing that the court were to consider, certainly the factors set out in the guidelines are the similarity, the regularity, or the timing. If the elements are all that matter, really the regularity and the time interval don't matter at all. It would be no use to have those as considerations.
I understand the argument, the logic of it, but there seem to be an awful lot of cases out there that say that one count of unlawful possession of a firearm is similar to another count of unlawful possession of a firearm and hold that it's relevant conduct under the guidelines.
There's certainly some cases that say that, although most of those cases are distinguishable from this case because of the regularity of the offense or the timing of the offense. There is at least one case where the court just concludes that if the elements overlap, then it's relevant conduct. However, that's not the precedent of this circuit. This circuit is the Duggar case is substantially similar to this case, is analogous because it's a drug offense where the court determined that the objectives of the actual offense matter. And in that case, there was actually, the conduct was more similar than the conduct in this case. In this case, there's three very distinct events. There's a shooting event, there's a drug offense, and then there's just simply a firearm case where Mr. McDonald was sleeping in a car. There was a gun locked in the glove box, and the police came up. They did a search of the car. There was no other contraband. There was no other illegal activity. There was no violence or aggression. Simply the possession of the drug was the only thing that was similar to the other events. To consider only that the elements of the offense would ignore this court's precedent, which requires similarity between the offenses, not merely an overlap of the elements. In Duggar, we had an overlap of the elements. Distributing drugs, it's distributing drugs, it's distributing drugs. Possessing a firearm is the same as possessing a firearm.
Does it matter that the district court, and I know you disagree with respect to the final finding as to the type of handgun, that each of the instances you were dealing with a high capacity magazine firearm, is that sufficiently similar to warrant a finding of relevant conduct here?
Our contention is that alone is not enough similarity. Certainly that is something that distinguishes a shotgun from a handgun, and that's fair enough. What the court goes on to say is, but that's really the only similarity the court can draw. The other surrounding factors of the events are not similar at all. And so the court does mention that he makes his findings that there were three guns, there were handguns, and that they were, I think he used the term extended magazines. And in his mind, that was unusual. But that's really the only distinguishing factor that he finds between the offense conduct or the three different events.
So in this case, if instead of the first two events involving drugs and firearm in the vehicle, if he had been shooting in those two as he was in the third one, would that be sufficient?
Yeah, I certainly think that would be more similar to the other two. And it's clear from where he stands to shoot back at circumstances under which the people fired at him, who fired at him, whether it was a man or a woman, whether the person fired from a gun, whether the person...
Pretty deep in the weeds, doesn't it?
I'm sorry?
So that gets pretty deep in the weeds on trying to figure out relevant conduct.
Well, I don't think that factor is so much related to relevant conduct, except to show that it's clearly not connected to a drug offense, and it's not connected to sleeping in a car somewhere. And, we're talking about a common scheme of plan, a spree is the definition.
Well, let me ask you about a specific case. Maybe that would help draw the distinctions. I assume you're familiar with the Fifth Circuit case of Brummett.
Yes, sir.
I know the government cited that. So that's three separate firearm possessions over a period of 9 months, which is identical to what we have here. So why is Brummett different, or why would it be wrong?
Well, Brummett is different. We've got 4 firearms over 3 separate occasions. Each of those firearms were found in the Brummett residence or a hotel where he was staying. Each of those offenses involved an ongoing drug investigation. Here we don't have that. This is distinguishable because there's no ongoing drug investigation of Mr. McDonald. There's no conspiracy alleged. And so each of these events is distinct from the other. Brummett is a Fifth Circuit case. It's distinguishable from the way the court analyzed a similar situation in this circuit where the objective of the offense is relevant to a finding of relevant conduct. Now, importantly, the distinguishing factors in the Duggar case, this court looked to the objective of the offense as well as the general nature of the offense to conclude that selling drugs in the prison was not relevant conduct because the offenses had different customers, different accomplices, different methods, and different purposes. The same is true for the different events in this particular case. One involved a girlfriend, and a gun was locked in the glove box, and the police actually had to pry it open. Neither Mr. McDonald nor his girlfriend had the key, or at least they didn't find the key, and they searched the car. One involved someone shooting toward Mr. McDonald, one involved drugs. All were in different locations. In considering the objection to joinder in this case, the trial court struggled to imagine how counts 4 and 5 would be admissible in trial of counts 1 and 3. Now, it's not directly analysis to the standard for relevant conduct in this case, but the court pointed out that if evidence of the counts could be admissible under Rule 404B, then the counts could be combined without prejudice. But the court severed the cases anyway because it could see no way that those counts could be relevant under 404B. A similar problem exists in the sentencing court's conclusions under the facts of this case. Supporting counts 4 or 5, if mere illegal possession of a firearm is by definition same course of conduct or part of a common scheme or plan, there'd be little, if any, logic in considering regularity or time. Possessing a gun at any time would be relevant to possessing a gun at any other time. And clearly that's not what the guidelines contemplate. The bare minimum for relevant conduct is one other offense. In this case, there were 2. It's hardly strong evidence of regularity. The shorter period of time would favor a course of conduct. Here we have a 9-month period. That is not the longest ever considered, but it's certainly not a short period of time.
Mr. Tyndall, can I go back to the question that Judge Floyd asked you earlier in the argument about the standard of review? Because I think it does matter in this case, or maybe it doesn't from your point of view. So the government urges that the standard of review should be for clear error. And obviously that's different, much more deferential to the district court than at the de novo standard with respect to relevant conduct. So you've already told us that you disagree with that, but let's assume that we think you're wrong and that the finding is reviewed for clear error. Is it clearly wrong for the district court to have made a finding that these were sufficiently similar events?
I think it's clearly wrong to find that under these circumstances, these were sufficiently similar events. The factual circumstances that distinguish the cases are, the court concluded that the presence of a gun with extended magazines were the similarities, as the court has pointed out earlier. There's not a lot more that the district court pointed to in concluding that one gun in particular was relevant conduct as to the other gun. So even under the clear error standard, I think that the district court clearly erred in making that factual finding that it's relevant conduct. Speaking of the factual findings, just briefly, I would point out that based on the review of the videotape, we would conclude that the court clearly erred in finding that the gun had a particular capacity, held a certain number, or was capable of holding a certain number of rounds. In addition, in finding that the conduct, Mr.
Does that make a difference to any of the enhancements?
It does make a difference. It's a difficult analysis, but it does make a difference to the enhancements, because only if the court doesn't find relevant conduct. So that would be the case. The three guns finding, it would not make a difference. It would make a difference. His factual finding as to the assault with the deadly weapon to an intent to kill, that finding, likewise, the court made that finding without analyzing the elements. And we would contend that it's clear error to make that finding based solely on what's viewed in the videotape. So,
Thank you, Mr. Tindall. You've got some time left on rebuttal, and we'll now hear from Ms. Niemeyer.
Good afternoon, and may it please the court. I'm Julie Niemeyer for the United States. With the court's permission, I'd like to start off by returning to the question posed by Judge Floyd and Judge Diaz regarding the standard of review in this case. The government contends that the standard of review is clear error, as clearly set forth by the previous authorities in this circuit, going back to the Hodge case from 2004, the Pauley case, 2002, all the way back to the Mullins case in the 90s, and more recently, the Pineda case and the McVeigh case, which established that when determining whether the court below erred in the application of the relevant conduct guideline, clear error is the proper standard. And that simply means that when the reviewing court looks back to all of the evidence, can they find that are they left with a definite and firm conviction that a mistake has been committed? And in this case, using that review, that standard of review, when looking at a situation with the defendant who is a felon, previously convicted, a felon in possession of a firearm, on probation for the felon in possession of a firearm offense, goes on to illegally possess 3 additional firearms, each equipped with an extended magazine, and doing so in public. There is simply no way to look at that determination and find that that was clear error.
We'll assume that we disagreed with you on the standard of review. Does that affect your idea as to how this case should go for you?
It does not, Your Honor. Even hypothetically, if this court were to conduct a de novo review, I believe it would reach the same conclusion. Going to the ultimate factors here that the court must examine, the similarity, the regularity, and the temporal proximity of the incidents, even if you were to evaluate each of those considerations de novo, I believe the court would reach the same conclusion. Mr. McDonald possessed illegal firearms under similar circumstances 3 times over a 9-month period.
Well, other than possessing the firearms, what were the similar circumstances?
Well, Your Honor, they were all out in public. Mr. McDonald armed himself with a loaded firearm in public, and each of those 3 firearms was equipped with an extended magazine. So the government would submit those are very key similarities in these 3 possessions.
Is that it?
I believe those are the strongest similarities, Your Honor. But also the defendant was on probation throughout each of those 3 possessions. And I think that's an important consideration as well.
Yeah, I guess the problem is, by definition, anytime you've got a felon in possession, that by itself obviously can't be enough. I guess the other thing that's helpful here to you is that it's not too far apart in time.
That's right, Your Honor. And under the authorities of this court, we have 3 very important precedents where a longer span of time was upheld as sufficiently related in time. The Pauley case from 2002 involved incidents occurring over 11 months, longer than the situation here. The Hodge case from 2004 involved 2 incidents occurring 3 years apart. And in the McVeigh case from 2014, there were 2 incidents that were 2 years apart. And moreover, were actually different offenses, a distribution of child pornography offense and a possession of child pornography offense.
Well, your opponent cited Duggar to us. Of course, you would agree those were about drug cases. Should we apply that same logic to a felon in possession case?
In this case, no, Your Honor, because there are simply not sufficient factual distinctions that are important in this analysis. In this case, the crimes were identical. They were committed under similar circumstances, being in public, being firearms with an extended magazine, a firearm possession committed while on probation. So each of those offenses was extremely similar to the other two.
So does it take all of the, I mean, we get a lot of felon in possession cases and repeats of felon in possession. There's some other circuit cases that seem to say that simply the possession by a felon of a firearm within a comparably short period of time is sufficient to show relevant conduct. Is it that simple, or do we have to have something else?
Well, Your Honor, every case has to be examined on the facts, of course. In some hypothetical situation, of course, there are differences and similarities that could be envisioned. But for example, in some of the cases, there are firearms possessed in one's home versus firearms possessed in public. But even in some of those cases, the courts, for example, the 10th Circuit in the Garcia case found that still was sufficiently similar. So when you're talking about a person who simply is prohibited from possessing firearms and then goes on to possess them, there are various circumstances that can all be considered relevant. It is all a series of incidents of the same nature that add up to a relevant course of conduct. There's one particular case that I believe is also instructive, the Santoro case from the 7th Circuit. In that case, there were 3 guns possessed over a 6 to 9 month period, but actually only on 2 different occasions. And then again, in the Garcia case, as I previously mentioned, there were 3 guns in that case on 2 occasions as well. 2 guns possessed in a public scenario and 1 gun possessed in a person's home. And
Opposing counsel just send us a case maybe from the 6th Circuit that rejected the Santoro line where there were 2 guns possessed on 2 separate occasions.
yes, Your Honor, I believe you're referring to the Amerson case from the 6th Circuit. I don't believe that case is persuasive here. First off, because the 6th Circuit has applied a de novo standard of review. And that's simply not the law in this circuit. We have always applied a clear error standard of review. Furthermore, I believe the Amerson case is not persuasive because they placed an overemphasis on the individual factual circumstances of each possession. One of the possessions was in connection with the shooting and one was not. The court seemed to believe that.
Do you see that the 6th Circuit case is just an outlier in these felon in possession relevant conduct cases? Or?
Yes, Your Honor, I would agree with that characterization, especially.
I just ask, I wasn't proposing one way or the other, but.
Yes, Your Honor.
Can I go back to the standard, and you may be right, I guess we need to take a look at this, but why would it be the case that you would test for clear error the factual findings with respect to the similarities or dissimilarities of the particular offenses? You know, they occurred, as you pointed out, they occurred in public, they involved high capacity magazines, and they were relatively short in time. Those are factual findings that you would obviously test for clear error. But then why wouldn't you test the question of whether or not those factual findings are sufficient to show relevant conduct de novo, because relevant conduct is a question of law?
Your Honor, the interpretation of what the relevant conduct standard means or when to apply it would be a question of law. But the specific application of the relevant conduct standard to the facts is a matter of clear error. And I believe that was clearly set forth by this court's holding in Pineda. And that was where they were examining the connection of 2 different incidents that both involved guns and drugs. And they reviewed those 2 incidents and the determination that they were relevant to one another under the clear error standard. So the clear error standard is appropriate when we are applying the standard to the facts. And the de novo standard would be appropriate if we were deciding which provision applied or how, whether a particular guideline was applicable in a certain case. But the mixed question of how the relevant conduct standard is applied to specific facts has always been reviewed in this court under the clear error standard.
So the determination in this case of 9 months, 3 incidences in 9 months, you're saying that's to determine whether that's sufficient under the relevant conduct guideline, that's a factual determination made under clear error review. It's not a question of law as to whether that's sufficient.
It's a determination, Your Honor, that involves a factual finding. And yes, that would be a clear error issue. Simply the fact that you are applying the relevant conduct standard to the facts does not make it a pure question of law. And that's what this court's precedents have shown us. There's also the case of Hawkins from 2015 in this court, which actually addressed the issue of joinder. But under those circumstances, the court found that simply 2 922G offenses were sufficiently similar offenses to qualify for joinder, in contrast to what happened in the Hawkins case, where they were considering joinder of a 922G offense and a carjacking offense. So, Your Honor, assuming the district court correctly applied that relevant conduct determination, what that means for this court is this: each of the 3 guns could be considered by the district court when applying the relevant enhancements. And so here 3 enhancements were applied. Of course, the 3 or more firearm enhancement, the high capacity base offense level, and the high capacity magazine enhancement. I'm sorry, I already mentioned that. The in connection with another felony enhancement. So each of those 3 enhancements, if the relevant conduct determination is correct.
The large magazine enhancement, you only need 1 gun, right?
Your Honor, there are 2 guns that support the...
Right, you only need 1.
Oh, yes, Your Honor, I misunderstood. Yes, only 1 is required, Your Honor. And there's evidence in the record that 2 of the guns were equipped with high capacity magazines. Those 2 guns were introduced into evidence at sentencing. The gun from the February 24th incident and the gun from the October 14th incident were both equipped with high capacity magazines, 16 or more rounds. And then finally, the in connection with another felony enhancement is supported by 2 different incidents that were considered by the district court. The drug conviction on count 1, and then also the assault with a deadly weapon with intent to kill, evidenced by the possession of ammunition in count 5. In sum, Your Honor, because of the relevant conduct determination by the lower court, each of those 3 guns established the enhancements applied. That determination cannot be disturbed except on clear error, and there is simply insufficient evidence here to reverse that decision on the clear error standard. If the court has no further questions.
No sooner. All right, thank you very much.
Thank you.
Mr. Tyndall, you've got some rebuttal time.
Just a couple of points. Counsel mentioned that all 3 guns were carried in public. It is true that the guns were discovered not in Mr. McDonald's home. One was in a car. He was not carrying the gun. One was discovered, it was acquitted conduct that was found near the scene of a drug offense. And one clearly from the video showed that he was shooting. Those are distinguishing factors. They may all be in public, but it's certainly different than someone each time being stopped carrying a gun concealed or on his person. I want to address the part about the enhancements, because certainly everything hinges on the relevant conduct with the enhancements. And certainly, as the court mentioned, you only need one if it's relevant conduct. But it is critical that if these are not relevant conduct to each other, certainly the gun from the shooting cannot be used as an enhancement for the drug offense. So it does change that analysis a bit if the court finds that this is not relevant conduct. Again, and back to the point of that the court asked counsel about the Amerson case, we would contend that the Amerson case is actually much more analogous to the Duggars case. Again, it's drugs versus guns, but the critical inquiry there is its elements versus elements. In the drug case, there were still the same elements. It might have been different drugs, and it might have been different locations. But in Duggars, that was the critical inquiry. The objective was different. And in this particular case, while the elements may be the same, the objective was different in each of the three events.
It's true that your client was acquitted in one of those cases that was considered by the district court, but isn't it the law that the district court can take those facts and apply the preponderance of the evidence standard and in determining whether that conduct is relevant?
Certainly, Your Honor. Okay. And we're not contending otherwise. As we point out in the brief, we recognize that is the law. We put that in for preservation only. We do think the Amerson case is an important analysis. We think it's more consistent with the findings of the precedent of this court. We believe that under the facts of this case, the court's analysis, the factual findings that based on the video, the court should find that the government failed to establish that the three separate events were relevant conduct. Without being relevant conduct, the firearm conviction for count 5 cannot be part of the base offense level for count 1. The 2-point enhancement for possessing 3 guns should be subtracted because finding possession of 3 guns requires a finding that the possession of each is relevant conduct. And finally, the 4-point enhancement for committing a felony while illegally possessing the firearm must be subtracted. Thank you.
Thank you very much, Mr. Tyndall. It is our traditional court practice at this point to come down and greet counsel, but that's a COVID prohibition at this point. So I do want to recognize, Mr. Tyndall, that you're court appointed, and the court expresses its appreciation to you for being willing to undertake that function. And we thank both counsel for their arguments today. And court will, if the clerk will now adjourn court for the day, will retire.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.